Hello and welcome to PCI Webinars. Today's webinar, How to Wrangle Contracts and Licensing for Your Library with Michael Rodriguez. Michael is the Licensing and Acquisitions Librarian at the University of Connecticut, where he leads vendor negotiations and contracts for library collections and services. He also freelances by teaching workshops on copyright, fair use, and other topics for clients such as Lyrasis, NAIRComp, RUSA, and of course PCI Webinars. Michael serves on committees for the Association of College and Research Libraries and the Library and Information Technology Association. He serves on the State of Connecticut's E-Resources Advisory Task Force and co-chairs the LEDA ALCTS Electronic Resource Management Interest Group. On weekends, he enjoys hiking and going on long-distance bicycle trips. Coming to you now from Connecticut, it's Michael Rodriguez.
Hello everyone, and thank you very much for having me today. Welcome to this webinar on wrangling contracts and licensing for your library. The slides will be displayed in a minute, but I'll go ahead and get started for us today. So, negotiating and wordsmithing legal agreements, it's really not a skill that's commonly taught in library school, is it? And it's usually not learned until you actually do it on the fly in the course of your work. So I'm delighted that you came here today because hopefully this webinar will help you get the jump on contracting if it's something that is new to you. And if it's something that you already have experience or expertise in, hopefully you'll pick up something that will inform your existing practices. Licensing is both a problem space and an opportunity for libraries because more and more of our collections are going digital, and digital content is typically licensed rather than sold outright. We're investing more heavily in cloud-based services, whether those are library systems or ebook platforms, etc. We're outsourcing a lot of our system content, so there's less local hosting of software and other services and more movement of that to the private sector and to the cloud. And what strong contracts can do is help us minimize the risk and maximize the benefits of those operations so that we can move forward and go about our work more efficiently with a greater sense of legal security and protection. And contracting really does impact a lot of people. So the terms that you negotiate in contracts have repercussions on your staff and on your users. And they are something that a lot of people in the library should be involved in one form or the other. Typically, I see electronic resources librarians, I see legal counsel, I see purchasing departments, finance, administration, any kind of library IT people. All of those folks are stakeholders in a lot of these licenses and should have a basic awareness of how to optimize those kinds of contracts. So here's my presenter information, and this essentially reiterates what Anne just indicated. I'm a licensing manager at the University of Connecticut, and some of my contact information is on that slide. So feel free to reach out to me at any time during or after the session. You can interject at any point in the comments area with questions or comments, and I'll be happy to answer those along the way. No need to wait until the end of the session. I will also throw out a disclaimer. So obviously I work at UConn. I'm not representing UConn today, and none of this presentation constitutes legal advice. It's really the perspective of an early career practitioner, seeing things with fairly fresh and critical eyes. I was brand new to licensing just 2 years ago, so hopefully what I will have to say to you will be helpful, especially if you're just starting out in this arena. So vendor contracts. We're all librarians here, or we work in libraries, or we manage libraries. So it's probably safe to say that we have a grasp of the essentials of what kind of library-specific things you want in a contract for ebooks, or for e-journals, or for some other kind of electronic material that we incorporate into our collections. So you want interlibrary loan clauses, for example. If you work at a university, you want to have a course reserves clause that enables you to take that digital material that you acquire and push it out to your courses through Blackboard or through some other learning management system. But what about the services contracts? What about software as a service? What about sales agreements? What about easy proxy or cataloging contracts? What about the library systems, the Sierra or the Alma or the WorldShare, those integrated library systems that we acquire from other providers? How do you negotiate those contracts? What kinds of terms are unique to not only e-resource licenses, but those kind of service agreements? That's something we'll be looking at today. And for me, it's really an important thing to highlight that this session goes beyond the e-resource license. Because with e-resources, typically the worst that can happen with a badly worded license that doesn't give you recourses is that you lose access to the e-journals or whatever the electronic content is. And you don't have a recourse, so you might be out some months of access. That isn't the worst thing that could happen, but that's usually as far as it goes. Whereas a contract that you have for hosting the library website or hosting Easy Proxy for your remote access users or Blackboard or any one of those kind of high value, high stakes service contracts, if that resource goes down during finals week, then everybody has a big problem. So in many ways, these kinds of contracts are more consequential and also more complicated than your typical e-resource license, which is already confusing enough. So this is why I really like the word contracts over licenses in most of these contexts. Because whereas license implies just some kind of click-through agreement, like the one that you automatically click yes to when you download a new version of iTunes, contracts really highlights the fact that this is a business deal. That when you sign a contract, whatever the value of that contract, you're entering into a set of mutually binding legal obligations. And it kind of behooves us to bear that in mind. I have a few kind of guiding principles for negotiating terms for a license. First of all, you want to negotiate flexibility of commitments on your side. So instead of saying, I will do such and such in your contract, what you want to write in is that you will use best efforts to do such and such, to give you a little more flexibility in meeting the commitments that you have entered into in that license. And we'll talk more about this later. Conversely, you want to hold the vendor, the service provider, the publisher, to specific commitments. And you want to not only specify exactly what the commitment is, but ideally want to set some kind of enforcement or assessment mechanism to make sure that the vendor remains in compliance with the contract. Also, look at each negotiation as a business opportunity. So yes, you want a good working relationship with your providers, and you want to strive for win-win scenarios where both parties walk away from the deal feeling like they got a good deal. But you do need to hold the vendor to account, and you do need to maximize the benefits for your organization. And sometimes that can require rigorous negotiations. The good thing is that negotiation can be surprisingly simple. It's actually a really complicated process, but if you boil it down to its essentials, negotiation happens when you ask for more and you are able to articulate why you should have more. Articulate and persuade. So yes, you oftentimes get pushback from the provider on particular contract terms, but generally speaking, I found that providers are, you and the provider are mutually invested in a satisfactory solution, and so generally an agreement can be reached that, while not ideal for one or both parties, is livable with. One of the most important things to bear in mind when negotiating is your BATNA. So what is BATNA? It has nothing to do with Batman. It's an acronym, and it stands for Best Alternative to the Negotiated Agreement. Basically, what would happen if one of the parties to the agreement walked away from the deal? What would be the repercussions on you, on your library, on your users? And what would be the repercussions on the vendor as well if the vendor chooses to walk away? Whether you have a weak or a strong BATNA really should inform how rigorously you negotiate. So if the vendor has a monopoly over the product, or if you absolutely need the resource and can't afford to walk away, then you may find yourself be forced to negotiate more circumspectly and accept a less than perfect deal. If, for example, you can get competitive bids from multiple companies. So you can certainly pit ProQuest and EBSCO against each other because their database products overlap so much. But to give you another example of the opposite effect, only the American Chemical Society publishes American Chemical Society journals. So they have a monopoly over that service or that resource, and therefore your leverage going into that deal is going to be probably less significant than if you were able to get competitive bids. Of course, it depends on how big your organization is too, and how much money is at stake in the deal. Companies are more likely to be flexible on terms when there are $2 million at stake than when there are $500 at stake. So let's talk first about vendor licenses and e-resource licenses. The first and number one takeaway I would get from this webinar today is to check out liblicense. The URL is at the top of your screen. It's liblicense.crl.edu. And what this is a set of templates and example language that was put together by the Center for Research Libraries way back in 1997. CRL is a kind of a global or consortium of top-tier research universities. And they put together this 20-page model license that you can go in and read and copy and paste bits of it into your own vendor licenses without any copyright concerns or anything like that. This is here to be shared and used and built upon freely by libraries. And it really is a wonderful resource. I highly recommend it. There's also a listserv that you can join and ask questions and kind of monitor the trends in licensing at academic libraries. And certainly liblicense is not the only such resource. I believe the American Association of Law Libraries, for example, has some really great model licenses on the web. And one thing I would do, which is often an underutilized resource, is talk to your state library or your state purchasing consortium. Lots of times they will, certainly in Florida and Connecticut, the state library acquires significant numbers of electronic resources for the entire population of the state. They have expertise and they have resources in contracting. So if you're a public institution in particular, or if you're new to the arena of licensing, or you want to beef up your practice, definitely reach out to the state library and see what assistance they can provide. If you're at a larger institution, I would definitely also talk to any kind of general counsel that you have, or have a conversation with your purchasing department, or even look at the website of your purchasing department. And again, if this is, particularly if this is a public institution, public university or city government or county government, again, they will often have templates and requirements and so on available for you. So limitation of the liblicense model, and this is kind of a challenge with licensing in general, is that it's weighted very heavily toward academic libraries and more toward research libraries. So if you are at a community college, some of the language may not be applicable to you. If you are at a public library, your eyes will probably glaze over with a lot of the clauses, but it is an excellent starting point. I will say that it tends to be a little bit heavy-handed with the legalese. So if you copy and paste just en masse, you're likely to, and you send that modified license with all this CRL language to a small publisher or a small vendor, chances are they'll freak out. So you might have to soothe them a little bit and explain your rationale and explain that they're not really losing anything by accepting these kinds of terms. A lot of my work with vendors seems to consist of relieving their minds. Okay, so let's talk about some of the actual terms. So one of the most common ones is authorized sites, and you really should not be seeing this anymore. This is back in the day when when pricing was based on the number of campuses or the number of library locations that you had. So for example, if you're a public library with 10 branches, then they would charge you based on the number of branches. If you were a community college, same thing. This model has kind of gone by the wayside to an extent, and now, and now you're more likely to see licenses in which pricing is based on the population served, the full-time enrollment, for example, or the population of the county, or the number of library card holders, etc. So you really should not be seeing site-specific language in any contract. And if you do, you should probably have a conversation with your vendor about it. Another issue with that kind of site-based license, and this still carries over today, is limiting access to the e-resource to people within the walls of your library. So for example, Ancestry.com Library Edition, the State Library of Connecticut subscribes to a really premium, amazing model of Ancestry.com. But in order to keep their pricing down, you actually have to be physically inside the State Library building in Hartford, Connecticut, in order to utilize that resource. So there's no off-site access. And this is definitely something I would challenge. It's usually, at this point, it really should not matter where you are in the world as long as you are authorized to access the resource, as long as you're an authorized user. And authorized users are another of those knotty problems. So if you're a university, and most of us are in academia here, I noticed, typically your authorized users are always going to include your faculty, your students, and your staff. That's kind of standard. But universities are more and more complicated in terms of who lives within them. So at UConn, for example, we have a technology incubation program. And basically this consists of pre-revenue companies, scientific researchers, biomedical researchers, coming on campus, renting space on campus, and taking advantage of some of the university resources in order to perform their work. But these folks are technically not students, faculty, or staff. So where do they fall in the contracts that we sign for library e-resources? Typically what we have to do is actually add them in as authorized users. So add a category of university-affiliated employees. So this is an important takeaway. If you have identity management folks, whether in the library or outside the library, have a conversation with them and find out exactly what kinds of users exist at your library. Is it just students, faculty, and staff, or are there other categories of user that really should be incorporated into contracts? And ideally, of course, ideally you should wordsmith a contract in such a way as to say that an authorized user is basically whoever the library says is an authorized user, whoever has a library card or borrowing privileges. You probably won't get them to accept that clause as the way I just described it, but that is kind of an ideal state toward which to strive, to be as inclusive as possible with who is our community of users. Then, of course, you get the authorized uses, and we'll talk about these. But obviously, for an e-resource, any authorized users are permitted to view it. But typically, and we see this a lot with ebooks, what are the other restrictions on this? Can the person download it? Can the person download it and keep it permanently? Or does it expire after 2 weeks, like everything in Overdrive? So those are some considerations to bear in mind, and we'll talk more about authorized uses with interlibrary loan. Certainly write a clause into any e-resource license specifying that your library can fulfill interlibrary loan requests for material for other libraries. That's kind of a requirement of being a good institutional citizen in the library world. And typically publishers are okay with it. I've gotten some pushback, mostly from publishers who are afraid that ILL will impact their revenue stream because people will rely on interlibrary loan instead of demanding their library get a subscription to the journal. But in most cases, they can be talked around. Scholarly sharing is an interesting clause, and this one features pretty prominently in LibLicense and is one of my favorite things about it. It doesn't have to be scholarly sharing, it can just be sharing. When an authorized user, when a student or a community member legally downloads an article or other digital material, and then sends that article to his colleague at another university or to her sister back home, who is not necessarily an authorized user per the license. And what you can do in that case is incorporate some language in LibLicense that basically legalizes the existing practice of researchers and other folks sending each other articles. Because it's going to happen. It's kind of inevitable that people share material. And you want to kind of legalize that as much as possible in the contract and give your community of users some layer of protection. Perpetual access is another big one for academic libraries, of course. And LibLicense has, I believe, 3 or 4 really nice paragraphs of language talking about how to ensure perpetual access. And this is kind of a snippet of that language. Essentially, according to this, you retain post-cancellation rights. So if you cancel a journal, you get to keep access to any of the copies, any of the issues of the journal during your period of subscription. And if the vendor can no longer provide such access itself on its own platform, then you reserve the right to get the material sent to you digitally and post it to a third-party hosting service such as Portico, or host it locally yourself on your own library servers. So this is definitely some useful language. Content changes. Again, this is a particularly important one with academic libraries because journals change hands so frequently. Publishers transfer them between each other. But it's also a significant issue, I think, for public libraries and streaming video subscriptions and other content. Because oftentimes, let me pick an obvious example and go with Netflix. So Netflix licenses, and I'm aware that libraries cannot subscribe to Netflix, but Netflix is a good example because they license videos from distributors, from the people who actually own the videos, the movies. And periodically, Netflix loses the right to distribute those movies. Their license runs out after 3 years or whatever, and they have to take down the movie so users can no longer access it via Netflix. This is also the case with libraries. Our vendors yank content that they lose the rights to or that they want to repackage and sell elsewhere, and we want to make sure that we continue to get our money's worth if the vendor pulls out a significant percentage of the journals in the package that we subscribe to. So if there's significant content changes, if content is removed or sold elsewhere, then ideally your license will state that ideally your license will give you recourse um, to ensure that if any of the material is transferred or acquired from another party, the vendor will use best efforts to ensure that the library does not lose access to that content. It's not a glamorous clause, but it's super important, and it's been quite helpful in ensuring long-term access to content. Data mining is an increasingly important one, again, on college campuses and especially at research universities when faculty and grad students are trying to conduct text and data mining of large volumes of content, newspapers, for example, digital newspapers. And for here, again, it's important to specify whenever possible in the contract that data mining is permissible. So, for example, you might want to state the following, as liblicense does very nicely. Basically, it allows your authorized users to conduct text and data mining as long as it's for non-commercial purposes and as long as you're not creating a substitute product for the material that you're data mining. And you also want to make sure that the vendor will support data mining and will not charge you extra for doing that. There's some area of flexibility here. So the couple models of data mining, first, the researcher could just run a script on the publisher's website, which, I mean, that increases the load time on the publisher's servers, but it doesn't really impact their operations. Or you can, or data mining can consist of actually downloading the publisher's content into a local database and querying that. And publishers tend to be more leery of that because it jeopardizes their control over their own content. So just be prepared to kind of fine-tune how your data mining provision is worded based on your faculty needs, but definitely attempt to include one in any contract. Fair use is another one. So the interesting thing about contracts, and one of countless fascinating things, is that contracts supersede copyright. So if you sign a formal agreement, then oftentimes you are actually limited to exercising the rights that are specified in that agreement. So you won't necessarily be able to claim fair use of material unless the option to claim fair use of that material was actually included in the contract. You can still go to court and argue the case, but your case is much stronger if you have backing, if you have language that is actually in the contract. So again, liblicense does a great job of pulling out some of that language, although this one is a little bit awkwardly worded and is probably something they'll need to revisit during the next iteration of liblicense. Okay, so before we segue into vendor contracts and kind of talking more about the legal clauses and the software type contracts, are there any questions for me so far? I'll give you a moment while I look through the chat. Someone mentioned that Choice does site licensing. So yes, there are a significant number of resources out there, and there are also a significant number to resources that will help you as you kind of negotiate and navigate these licenses. But there are also a lot of consortiums of library groups and providers that actually get together and license on your behalf. So you'll find the Northeast Research Libraries has an association. Center for Research Libraries does licensing on behalf of its member libraries. Certainly Lyrasis does that. There's a fair few options out there. So that's definitely one One avenue of avoiding some of these complexities of e-resource licensing is just going out and finding a consortium that already has licensed this product on behalf of its member libraries and joining that consortium. So you can kind of simplify all of your efforts. University of Connecticut is a member of Neural and the Neural Consortium, and it's proven extremely cost efficient as I don't have to negotiate an extra 25 licenses every year with providers. Yes, and choice charges by the campus, it looks like. I see what you mean. Um, yeah, they do that, and that's kind of annoying. Um, Chronicle of Higher Ed has a weird pricing pattern as well, and which one was it? It was the Harvard Business Review, I believe, that doesn't actually allow you to download it. You have to read it online, which is strange and unusual. But I guess they want to retain their monopoly over the content and don't want to lose control over it, which is an understandable impulse, although it's frustrating from a library and user perspective. Okay, let's segue into vendor contracts. So liability, that's always the elephant in the room, right? That's the first thing you think of when you hear the word insurance or when you hear the word contracts, right? It's liability, legal risk, and financial risk. So obviously what you want to do in any kind of contract is minimize the liability for yourself and for your organization. And what I've done in these following slides is actually go through some real-world contracts. Some actual contracts that I've negotiated or I've encountered over time. And I've pulled out excerpts of those contracts as they were originally written at the top and as they were ultimately written or should have ultimately been written at the bottom. So red light and green light. Most of these are real-world contracts. None are subject to non-disclosure agreements, though, so I am allowed to share them with you. And a few of them are actually ones that I've developed myself as kind of somewhat exaggerated examples of how problematic vendor licenses can be. So let's take a look at liability. So this one specifies that the customer shall take reasonable steps to ensure that the authorized users will use the product according to the terms of the agreement. Okay, that's fine. Reasonable efforts is good. But then it says that the customer will indemnify the vendor against any claims or losses arising in whole or in part from any violation by the customer. Never agree to indemnify anyone for any reason. Indemnification essentially you can almost frame it as a pre-admission of guilt and certainly a pre-admission of liability. So avoid indemnifying anyone for any reason. You can agree to remain silent about the whole issue of indemnification. But at the state of Connecticut, we actually have a legal statute saying that the state of Connecticut cannot agree to indemnification in any contract, which has been very useful when negotiating with vendors. We can just point out the state law. Another clause that's problematic is the customer assumes the sole responsibility for all use of the products by its authorized users. No, definitely do not agree to that. What is implied in that sentence is that any behavior by your students is fine. Is not fine, is behavior that you assume legal responsibility and liability for, even though you really have no control over it. If the person's an authorized user, if they have a login, then you really can't control if they then give that login to Sci-Hub and download thousands of articles in violation of your contract. That's not something the library can enforce or control. So definitely don't agree to any kind of sweeping language of that nature. Instead, what you want to do is, again, say that we will take reasonable steps to make sure that authorized users do the right thing. But authorized users are not party to this agreement. In other words, if there is a breach by a single user, then the vendor would be able to go after that one person in the courts or whatever, but would not hold you liable along with that user. And if at all possible, get the provider to admit that the customer cannot monitor, control, or proactively enforce the behavior of authorized users. Because we can't. That's not really in our hands. That's up to the university IT department and human resources and student services to make sure that people are being cycled in and out of the system and are assigned the appropriate permissions. That's not something the library can fully control. Non-disclosure. So this one's, oh, and I actually forgot to mention in the liability section, there are a lot of other things that go into liability indemnification that kind of fall into that area. So jurisdiction is another important one. So if there is a court battle, in which state's courts will that case be taken, be settled? Typically, you want to say that the jurisdiction is your state, is the state of Florida or the state of Connecticut, if that's where you live, because your lawyers are more familiar with the laws of that state, and if you're a public agency, then you may be protected by the state sovereignty or by your relationships in the system. So definitely don't, if you're based in Connecticut and the vendor is based in Delaware, do not agree to that any disagreements will be governed by the laws of Delaware, because you'll be at a disadvantage in that context. And the same goes for governing law. You want, ideally, you want the law governing the contract to be your local laws, not the vendor's laws. Oh, thank you, Glenn. I appreciate the feedback. Glenn mentioned that this is some good information. So non-disclosure. Sorry, we went through a yellow detour there. Non-disclosure is really annoying. And I say that advisedly, because vendors are kind of sneaky about this. They will phrase non-disclosure agreements, or NDAs, as confidentiality, which sounds great, right? We want our users' information to be confidential. No, you're agreeing to keep the vendor's information confidential. You're agreeing to keep the contract itself confidential, typically, so you won't disclose it to anybody. Typically, you agree to keep the pricing confidential. And if you really go overboard, as with the red light clause up at top on this slide, you will agree to keep everything confidential. Every email, every interaction, every phone conversation, and every bit of information that you become peripherally aware of about the vendor, unless you're sued in court and you have to disclose it due to a legal process. And if you violate that, if it's as simple as you sending an email to a colleague at another university and saying, wow, Elsevier gave us really bad terms on this deal, or ProQuest pricing is a lot lower than EBSCO's, something along those lines, then that could technically be considered a breach of your NDA agreement that your university signed the moment your dean or your vice provost or your director inked that contract. So what you want to do is leverage specificity here. Force the vendor to be very specific about what they want to keep confidential. Typically, you will get them to agree to keep only the pricing confidential, or maybe the contract itself confidential. But try to get even more specific than that. Try to get the vendor to say, pricing shall be confidential for only 3 years, after which you can legally disclose that pricing. Or specify that only particular sections of the contract will be held confidential during that period, rather than the whole entire contract forever. So you can get as granular as you want here, but overall, libraries And government institutions and public service agencies, we want to be as transparent as possible, and we want to get good deals for taxpayer dollars, in particular if you work for a public institution. So it's in our interests to strike confidentiality and non-disclosure agreements whenever possible, or at least water them down. Exclusivity is kind of an interesting one. So I rarely see this, but I do see it occasionally. What exclusivity means is that the library agrees to do business only with that one vendor. So for example, if you're going to move from Microsoft to Google and you're looking at the email platforms and trying to decide which is better, and you go and sign a contract with Google, then Google might ask you to agree to an exclusivity clause that says you will not do business with Microsoft unless we give you permission to, at least not in the area of document storage or email or anything else, any other service that Google could provide. And this also applies in sales agreements. When you sell off surplus books or equipment, a lot of times vendors will attempt to make an exclusive deal with you. Generally, you don't accept that. You strike that clause and you write intentionally omitted instead. Because it's really not good business practice to agree to exclusive deals unless you're getting an incredibly good deal. And as libraries, we very rarely get incredibly good deals. So try to strike this. Warranties is a little bit more complicated. So, I mean, if we've ever bought anything, we'll have seen those lists of warranties. So this product will not break down until after a year. Rather simplistic, but a good summary, I think. Okay, but when we look at software, typically we'll see warranties such as this one, right up at top. So software is provided as is and is exclusive of any warranty, express or implied, including, without limitation, any warranties of merchantability, fitness for a particular purpose, or non-infringement. No. Non-infringement means that the vendor could be selling you software that the vendor does not have the right to distribute, that is actually owned by somebody else. And by accepting a non-warranty of this nature, you're kind of weakening your case if you, in turn, get sued by whoever owns that software, whoever actually owns that software. So you always want to require vendors to indemnify and hold you harmless if any components of the software infringe on someone else's copyrights. And in most cases, vendors recognize this and preempt this even in their standard licenses. But I've seen cases where they did not, where they refused to guarantee that they actually own the rights to distribute the stuff they were selling you, which is really not acceptable. And what was the other one? Fitness for a particular purpose. Yep. So you'll probably not get them to modify this language. It's almost universal in software licenses. But what you can get them to do is agree to incorporate the service level agreement of the product. So, and any documentation, incorporate that into the contract. Just slap the word Appendix B on it and incorporate it by reference into the contract. Because what that does is include in the contract a clear sense of what the resource can actually be used for, what it was designed to be used for, what its capabilities are. E-journals are designed for research. Mendeley is designed for citation management. That's not necessarily a particular purpose, but it is a purpose. And you want to kind of incorporate into any contract what that purpose is. Because ultimately that facilitates accountability, your ability to hold the vendor accountable for promises made. And here again, talk about service level agreements. I would probably not make mountains out of molehills here, so you don't need to spend a ton of time holding the vendor accountable line by line, but it is a principle to bear in mind, and it's particularly important when it comes to stuff like uptime. So what percentage of the time a system, for example, is online. So this came from a contract I recently negotiated. It stated that the vendor will use reasonable efforts to ensure that the systems are available during 98% of the year. Great. 98% of the year, however. Okay, so there are 8,760 hours in a year. Okay, 2% of that could be downtime according to this contract. So that means 175 hours the system could be down per year, or 7 days. And if those 7 days fall during exam week, then Houston, we have a problem. This is particularly problematic if those downtimes are calculated to exclude outages due to maintenance, scheduled or emergency maintenance, etc. If it's scheduled maintenance, it really should be included in the downtime. I mean, that should have been anticipated well in advance. So what you want to try to do is first increase that uptime threshold. 98% is the absolute bare minimum. For a really good service, it should be more like 99 point something percent, even 99.9%. You might not get them that high, but you can try. Let them talk you down. In the event that the firm fails to meet the uptime commitment for any rolling 3-month period, institutions shall receive a refund, a prorated refund for that period of non-access, which is excellent. Again, you want to hold the vendor accountable and be able to enforce the promises that they make whenever possible. Consortium memberships. So remember earlier I mentioned consortiums like Neural and others that you can get your licenses negotiated through. Well, those consortium memberships can actually be kind of problematic from a legal perspective, from a strictly legal perspective. Because in the law, typically, membership and consortium imply entities going into business and creating shared liabilities. Like if you and your buddy buy a boat together, then you've kind of formed a consortium that co-owns that boat, and you've created shared liabilities. So if that boat sinks due to negligence and kills somebody, then the family of that person who tragically perished can sue both of you because you were both responsible for that boat. So our legal counsel is very cautious around consortial memberships. What he tries to do is instead call them participation agreements, and he makes sure to highlight in the membership agreement or participation agreement that the university cannot be held liable or responsible for any obligation of the consortium or its other member institutions, and that we reserve the right to leave the consortium at any time for any reason, and that departure kills any obligations of ours to the consortium. I don't think we've never had to exercise this because most consortiums are really wonderful collegial groups of libraries and colleagues, but it's good to have this language in your back pocket, again, so that you can minimize risk and proceed and operate securely. Terms of use are, again, kind of, they're bothersome. So terms of use would be those click-through agreements, and they can be in addition to a signed license. So what you want to do if you see a click-through agreement, you want to make sure that that click-through agreement is superseded by your signed contract. So if they change the click-through agreement, then the governing document is still the contract that you signed. Because click-throughs change all the time. How often does Apple or Google change its terms of use? Enforceability. So this one basically means when is an agreement binding? If you sign what is called a memorandum of understanding, typically those are understood not to be binding. Actually, it depends on how the courts interpret that, because anything can be binding without having been signed or formally considered a contract. You can make verbal contracts, for goodness sake. So be cautious around memorandum of understanding. Just know that they can be interpreted as a contract unless you very specifically state that this is not a contract, and none of the provisions therein are enforceable. This is particularly the case, again, if it's kind of an informal group of libraries that get together for a particular purpose and are not fully incorporated as a company. Then they might request folks to sign a memorandum of understanding. Right to audit. Basically, just say no. Nope. If you allow a vendor to claim the right to audit in a contract, they can come to your campus and demand your documentation and demand proof that you complied with the license. And if they find out that you didn't, then they can hit you with penalties. So never accept a right to audit clause. It's really just not acceptable in any context. Data ownership and usage. So remember that to protect your patrons' data. And remember to keep ownership of any data that you provide to a company. So if you use social media, if you sign a contract with Blackboard, you still should retain ownership of any content that you put into that system. Also, you should remember that the data is not just necessarily personally identifiable data. It could be the words that you type into search boxes, like the search inputs. It could be patterns of usage. Anything that the vendor could then leverage to increase the value of the resource or product it's selling you. So just make sure to retain ownership and require the vendor not to sell or disclose any of the data to third parties or use the data for any purpose other than the permissions you have given them. Kind of lock down your data as much as possible. And you want to also make sure, and this is particularly the case with our outsourced library systems and services like Iliad for ILL, or Alma, or WorldShare, or Sierra for your ILS. You want to make sure that that data is backed up, that it is secure from loss or from hacking as much as possible. And you want to make sure that any subsidiaries or contractors of that vendor are held to the same standards. So again, the goal here is to be specific. Don't just allow the vendor to get away with some generic statement like we are committed to keeping your data safe and secure. Have them explain exactly how they do that. And you don't necessarily need to have that written in black and white in the license itself, but you need to have a clear understanding from them of how they protect your data. User privacy, we kind of talked briefly about that, but this is particularly important when it comes to HIPAA and to FERPA compliance, which as universities we need to be aware of. So HIPAA, we keep our patient data private. FERPA, we keep our student data confidential. And typically what you want to do here is talk to your university's compliance office or the dean of students or the director of the hospital, whatever. Because typically they will have very specific language that you have to incorporate into your contracts. And you want to make sure that you're aware of that language and that you write it into any contracts to which it may apply. Transfer of title. So again, that's important mostly for physical shipments though. So if a physical shipment of books gets lost in the mail, but you officially received ownership of that material as soon as you paid the bill, then you're basically taking on yourself the onus of following up with USPS or the delivery agent and recouping the loss of those materials, rather than accepting ownership only on delivery and acceptance by the customer of the products in the agreed upon condition and working order. Non-disparagement, this one you usually don't see, but I've seen some really nasty examples of contracts for journals or ebooks attempting to prohibit the users or the library from commenting critically about the product or about the company. And again, the only reasonable response to this is striking it completely from the contract. It's also important to comply with the Americans for Disabilities Act, the ADA compliance. So what you want to, universities have been taken to court simply because they did not close caption the videos embedded in their learning management systems. And they're usually state and federal or institutional mandates to support users with disabilities. So you need to be keenly aware of those, and you need to write into every contract a statement that the contractor will comply with the American with Disabilities Act and will support assistive software, will be able to articulate to you in what areas they comply with and in what areas they are trying to improve, and also give you the right to adapt any of the material to support users with disabilities and to comply with the laws governing that. Last example is force majeure. So these are basically acts of God. And these are invoked when the contract states that the obligations of one or both parties are waived in the event of one of these situations over which the parties have no control. So if there's a fire, if there's a riot or a war or a hurricane, something like that. So for this, my advice is to look very closely at the conditions they are specifying as acts of God. Because if you look at this example, lockouts are not acts of God. Those are deliberate choices by the vendor to lock out their unionized employees. That's under their control. And the same if any suppliers or subcontractors are delayed. Again, that is somewhat under the vendor's control. They should have ensured that those suppliers could keep the timelines and should redress that accordingly. So keep an eye on force majeure. It's a necessary clause, but be cautious with it. I highly recommend these readings. These are really great perspectives from both the library and the private sector about how to negotiate contracts effectively. And in conclusion, I would say that licensing and contracting ultimately comes down to an extent to priority management. So we have so much on our plates, and we have a wide range of the level of risk for each of these. So choose what contracts to prioritize, which to negotiate most heavily on, and hopefully you'll both keep your library safe and secure from legal concerns, and you will also be able to maximize the benefits of that contract or license or resource for your users. And hopefully you will be leaving this session today with a clearer understanding of how to do that. Thank you very much. And if you have any questions, I would be delighted to take them now. While folks are typing into the comment box, if anyone has questions, you can see my contact information on the top right of the screen. Feel free to tweet at me or send me an email at any time if you have a follow-up question that we're not able to get to today.
Thanks, Michael. Great job. Hey, Michael, thank you so much for doing this. I know it's a lot of content that you put together. Really well done. Very well structured. We appreciate that. I see no other questions, so I just want to thank you once again for attending. We hope you had a great time. Remember, we have webinars next week on Tuesday and Thursday, and then we're shut down for a couple weeks for the holidays. So thanks, everybody, and thanks, Michael. Have a great afternoon.